Check out carmarshal.com. The link is in the description. They help support us.
When Punta Gorda officer Bonnie Buckelew isn't patrolling the streets, she enjoys doing home repairs at her Mayaca City home.
We are do-it-yourselfers.
So this summer, when she found out she needed a new roof, she started working on it with her boyfriend, who is a Sarasota deputy.
I just figured somehow I'll figure it out. I always do.
But then, mid-project, Hurricane Irma started barreling towards Florida.
When I left, I was scared and high anxiety and worried to death because not knowing if my house was going to be here when I got back.
The two officers spent 4 days away from home during Irma.
We were just basically doing anything and everything to help whoever. That's most important of keeping those citizens safe. Your stuff comes last.
When they returned, the roof was still a problem. Until the GAF Shingles Company heard their story of giving back, and the company did all the work for them.
I felt like Miss America. I was like, because I would never in a million years ask for anything.
Severance Agreement and General Release. This severance agreement and general release, the agreement, is entered into by and between the city of Punta Gorda and all its present, past, and future officials, officers, employees, insurers, attorneys, representatives, and agents, and all their heirs, successors, and assigns, referred to herein as employer, and Bonnie Buckelew and all her successors, heirs, and assigns, referred to herein as employee. Whereas, employee is employed by employer, and whereas, employee filed that certain charge of discrimination numbered 510. 2017-04308, charge, with the U.S. Equal Employment Opportunity Commission, and whereas employee and employer desire to end the employment relationship between them and, by this agreement, to avoid the uncertainties and burdens of disputes, and instead, desire to settle all actual or possible disputes between them. Now, therefore, employee and employer, in consideration of their mutual promises and other good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged, and intending to be legally bound, do hereby agree as follows. 1. Representations. Employee and employer acknowledge that the statements set forth above are true and correct and adopt them as if fully set forth here. 2. Resignation, no re-employment. Employee agrees that her execution of this agreement constitutes her immediate and irrevocable resignation of her employment by employer. Employee agrees that she will not seek nor XDT re-employment BV. Employer. 3. Withdrawal of charge with prejudice. Employee agrees to withdraw the charge *idle p at en her execution of these agreement. 3. Consideration, taxes. In consideration of the promises made and obligations undertaken by employee herein, including, but not limited to, the release of all claims by employee against employer, employer agrees to pay employee the sum of $100,000. The payment will be by check payable, such check to be delivered within 7 days of the effective date of this agreement. No taxes or other deductions or withholdings will be made. Employee is responsible for all applicable taxes. Employee acknowledges that this payment is ample and adequate and that she would not be entitled to this payment but for her entry into this agreement. Employee agrees and acknowledges that the payment is the only payment or benefit to which she is entitled from employer except as otherwise expressly set forth herein or provided for by law, if any. The payment will be reported by employer to the IRS on a Form 1099. Should it be determined that taxes should have been withheld or paid on the payment, employee shall be solely responsible for paying them, and will indemnify employer for any and all payments, including interest or penalties. It is of this agreement, employee irrevocably, knowingly, and voluntarily releases, waives, and forever discharges any and all claims, demands, actions, causes of action, charges, and /or disputes of any kind, whether known or unknown, foreseen or unforeseen, foreseeable or unforeseeable, and any consequences thereof, which she has, had, or may now have against employer, whether based in tort, contract, statute, or on any other basis. These claims include, but are not limited to, any and all claims or causes of action she has, had, or may have, arising from the events upon which the charge is based. The disputes released also include, but are not limited to, claims under the U.S. Civil Rights Act of 1964, as amended. Sections 1981 through 1988 of Title 42 of the U.S. Code. The Constitutions of the United States and of Florida. The Employee Retirement Income Security Act of 1974, as amended. Any state or federal whistleblower statutes. The Internal Revenue Code. COBRA. GNA. USERA. The Americans with Disabilities Act of 1990. The Florida Civil Rights Act. Chapter 440, Florida Statutes. Chapter 448, Florida Statutes. Chapter 447, Florida Statutes. The U.S. Equal Pay Act. The Family and Medical Leave Act. The National Labor Relations Act. The Age Discrimination in Employment Act. Any other federal, state, or local law, regulation, or ordinance, without limitation. The parties acknowledge that the list above is illustrative and not exhaustive, and that the release provision of this agreement is intended to be construed as broadly as possible to cover any and all claims employee has, had, or may now have against employer. Employee acknowledges that she may later discover facts in addition to or different from those she now knows or believes to be true with respect to the subject matter of this agreement. She agrees that such discovery shall not affect this agreement, that she assumes the risk of such discovery, and that this agreement shall remain in full force and effect and shall not be subject to rescission by reason of such discovery or difference in facts. Employee acknowledges that she is waiving not only her right to recover money or obtain other relief based on the claims released herein, but she is also waiving her rights to recover money or obtain other relief based on any action that might be brought by any other person or entity. Employee hereby represents that she has been fully paid all wages to which she is entitled, including, but not limited to, overtime payments, if any. The parties agree and understand that this agreement does not affect employees' right to file a charge or participate in the investigation of a charge by the EEOC or similar Fair Employment Practices Agency, and that this agreement is not intended to and does not interfere with the enforcement authority of such agency. This agreement is not intended to and does not waive or seek to waive any claim or cause of action as to which waiver is prohibited by applicable law. Employee conclusively represents that she has disclosed any and all compensable injuries. Employee conclusively represents that she has been paid all wages and compensation of whatever kind and at whatever rate to which she is entitled. 5. No lawsuits or claims. Employee agrees not to institute or have instituted on her behalf any lawsuit, charge, or claim of any kind against the other based on the claims she is waiving in this agreement. Employee represents that she does not now have pending any lawsuit, charge, or claim of any kind against employer other than the charge. If it is determined that employee does have any pending claim of any kind against employer, employee agrees to immediately withdraw or dismiss such claim with prejudice. 6. Older Workers Benefits Protection Act/ADEA. A employee agrees and represents that this agreement is written in understandable language and that she does actually understand this agreement. B. This agreement is intended to and does waive rights under the Age Discrimination in Employment Act, as amended, and the Older Workers Benefits Protection Act. C. This agreement does not waive any rights arising after the date the agreement is executed. D. The consideration received by employee pursuant to this agreement is in addition to anything of value to which she already is entitled. E. Employee has been and is hereby advised in writing to consult an attorney prior to executing this agreement. F. Employee has had ample time of at least 2 days in which to consider this agreement. G. Employee may revoke this agreement within 7 days of the execution of the agreement, the revocation period, by her. In order to make an effective revocation, employee must deliver a written notice of revocation to Philip Wickstrom, Manager of Human Resources, City of Punta Gorda, 326 West Marion Avenue, Punta Gorda, Florida, 33950. The notice must be headed Notice of Revocation and must make clear and explicit reference to this agreement and must state, I hereby revoke the severance agreement. The notice must be actually received at the address of Mr. Wickstrom no later than 5 p.m. on the 7th calendar day following the date that employee executes the agreement. In computing the revocation period, the date of signing shall be excluded and the next 7 calendar days shall constitute the revocation period. However, should the 7th day fall on a Saturday, Sunday, or state or federal holiday, the end of the revocation period shall occur at 5 p.m. on the next following business day. 7. Consultation of attorney, adequate time for consideration. Employee acknowledges and agrees that employer has and hereby does encourage her to consult an independent attorney of her own choosing to counsel her as to the meaning and legal import of this agreement and all its terms. Employee acknowledges and agrees that she has had ample time of at least 2 days to consider whether to enter into this agreement and, if she has not used all 2 days, waives whatever portion of that time she has not taken. 8. Effective date. This agreement is effective upon expiration of the revocation period, provided that an effective revocation has not been made. 9. Severability. If a court of competent jurisdiction declares illegal, invalid, or unenforceable any provision or provisions or part thereof of this agreement, excepting only Paragraph 4, Release and waiver of claims, hereof, which provision or provisions cannot be made legal, valid, or enforceable, such provision shall immediately become null and void, leaving the remainder of this agreement in full force and effect. 10. Disputes. This agreement shall be governed and construed according to the laws of the state of Florida. The language of the agreement shall be construed as a whole, according to its plain meaning, and shall not be strictly construed against any party. In the event that any party to this agreement institutes legal proceedings in a dispute arising from this agreement, it is stipulated and agreed that such claim shall be heard by a judge and not a jury in Charlotte County, Florida. Employee agrees that venue is proper in Charlotte County, Florida, and further agrees that she will not challenge or object to said venue. It is agreed that the prevailing party in such a dispute shall be entitled to all its reasonable attorney's fees, expenses, and costs, including appellate fees and costs. 12. Counterparts, signatures by electronic transmission. This agreement may be executed in counterparts, each of which shall be deemed an original and which together shall be deemed one document. Any signature affixed to this agreement and transmitted by electronic means shall be deemed an original and shall be valid and effective for all purposes. 13. Headings, singulars and plurals. Section headings in this agreement are for convenience only and have no legal effect. As used in this document, the singular includes the plural and the plural includes the singular. 14. Acknowledgement. Employee has read, understood, and fully considered this agreement and all its terms. Both parties acknowledge and agree that this agreement is the product of mutual negotiation and compromise between the parties. Having elected to enter into This agreement, to fulfill the promises set forth herein and to receive thereby the benefits set forth herein, employee freely and knowingly and after full consideration, enters into this agreement intending to waive, release, and create a final bar to any and all claims she has, had, or may now have against employer from the beginning of the world to the effective date. 15. Entire agreement, modification. This agreement constitutes the entire agreement between employer and employee regarding its subject matter. Employee agrees that she has relied on no promises, representations, understandings, or communications of any kind, written or oral, in agreeing to enter this agreement other than those set forth expressly herein. This agreement may be modified only by writing signed by employer and employee or their respective successors, assigns, or authorized representatives. In witness whereof, employee and employer have executed this agreement and general release as set forth below. Employee, employer. City of Punta Gorda. Bonnie Buckelew and Punta Gorda City Manager. Signing off is Howard Kunuk.
County, this is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Charlotte County COPWATCH with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me and I'm sick of it, so I'm trying to wake people up. But my wife would love it if if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave let's say actually yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where at least I can do it. 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is if I got some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here, and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. 47,000 of you so far right now. $1 a day. $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head, help out. This is a lot of work every single day. Thanks.